Good afternoon, ladies and gentlemen. We are here to discuss, we have created a webinar to discuss various challenges that the stakeholders are finding during the CIRP or the liquidation process of real estate entities. So, first of all, I'll just like to give a brief of the agenda that we have today. See, enactment of the IBC along with the RERA has ushered a new era of regulation for the Indian real estate sector. Both of these reforms have strengthened the hands of the buyers, home buyers, the real estate allottees, and providing them alternative forums for getting justice. The bankruptcy reform intends to counterbalance the interests of the lenders as well as defaulting enterprises management. Promoters now fear that there is a possibility of losing the ownership, and that's why they act in a better way. However, CIP in the real estate sector presents its own sets of challenges for the stakeholders, including the RP, the ARs, and definitely the creditors. Very often, real estate allottees are conflicted with the choice between RERA and IBC. Even though the superiority of IBC is beyond dispute, lack of awareness of the issues sometimes lead to considerable discord among the buyers and various stakeholders. Projects get stalled, though temporarily, due to initiation of CIRP, which another cause of worry to the stakeholders, particularly when they have got a RERA order in their favor. Professionals, CIRP professionals, IPs too have to contend with multiple challenges. For instance, the task of responding to the swarm mails amount, which can be hundreds of buyers, home buyers, is a task to reckon with. Responsibility of coordinating with all the allottees is a difficult challenge that IP is posed with. Likewise, ARs, they have to deal with all the allottees, large number of group of allottees, their different concerns. Everybody has its different set of issues. Therefore, the objective of this conference is to highlight or bring forth the CIRP of real estate entities. What are the problems? What are the possible solutions my learned speakers, the panelists can share their experiences, and how the regulation has grown over a period of time. We'll discuss key areas, some effective solutions with a futuristic approach, and to showcase the points to be incorporated by the finance industry as a whole. The session will be a platform for industry experts, financial institutions, consultants, and experienced professionals to share their experience and ideas in this regard. We welcome the questions, if any, that we will consider at the later stage of this webinar. The program agenda is to bring major challenges and probable solutions to the RPs and ARs in the real estate. Conflict of interest between secured financial creditors and home buyers in some cases. Dealing with ongoing and new litigations. Challenges relating to voting and approvals. Pre-packs, is it possible there? Addressing some concerns of the home buyers, and challenges in raising interim finance or to run day-to-day operations. I have an elite group of panelists here to discuss this objective or subject. I have Mr. Anand Sonbhadra. He is senior partner from AAA Insolvency Professionals LLP. So over 30 years of experience and has industry-specific experience of strategy, scaling up of business, turnaround of running businesses, managing global operations, mergers and acquisitions, cross-border acquisitions, tax-efficient legal structures he can create for acquisitions and operations. I'm welcome Mr. Sonbhadra. I also have Mr. Nilesh Sharma. He is first partner of Triple R Insolvency Service Experts LLP. He is an IP registered with IBBI. See, he was among the first 15 insolvency professionals in India who were provided the registrations of IPs by Ministry of Corporate Affairs for a period of 6 months based on experience on the field of insolvency and bankruptcy. Now, these are the people who are stalwarts in the field of insolvency. I am also having the CMA, the cost accountant, Mr. Dharmendra Kumar. He is Associate Director with Decode Resolvency International. He is an IP with more than 28 years of experience, including industrial experience of general management, commercial finance, tax, risk management, audit, internal control, and compliances. I welcome Mr. Dharmendra.
Thank you, sir.
I am also having Mr. Milan Singh Negi. He is an advocate. Mr. Negi is a practicing advocate, having his office in New Delhi. With his worthy experience in the field of law, he excels across various verticals of litigation, dispute resolution, risk advisory, especially in the insolvency resolution of debt, finance, restructuring of companies. And last but not the least, I am privileged to have Mr. Anirban Banerjee, Head Service Delivery Excellence in Tata Capital Services. He is a Bachelor in Engineering of Computer Science, a postgraduate diploma in Business Management, a cost accountant, and MPhil in Economics. So overall, with an overall experience of more than 20 years in business acquisition, banking operations, operational risk management, he is the head of service delivery excellence in TCS, BFSI, infra service operations, intelligent automation ops, directly responsible for delivery excellence and risk management. Welcome, Mr. Anirban.
Thank you for having me here.
I welcome you all, gentlemen. I hope that this webinar will give a perspective to the people present here and people present on the YouTube channel, which is also going live. First of all, sir, before starting this, I would request you to share some of your experiences in very briefly, or some specific experiences that you have during your experience with IBC, particularly with respect to the real estate. I will start with Mr. Nilesh Sharma. Sir, can you share very, very briefly some very specific experience for the knowledge of our viewers and participants?
Yes. So recently I have completed 2 real estate matters where resolution plans have been approved by the COC, and the resolution plans are now pending before NCLT and for their approval. So in one particular matter, in which my friend Mr. Dharmendra Kumar was also an AR representing one of the class of home buyers. So there, and in both the matters, another one where I was having 4 projects, and I constituted separate classes of creditors, separate classes of financial creditors. And because all those 4 projects were totally different projects, they were at different stages of completion, and their interest according to me were different. So I constituted separate 4 classes, and based on the same, the entire process has been completed. In another matter, the problem was that only one project was there, and the home buyers, there were certain class of home buyers who were the original home buyers, and same flats were had been sold by the promoter to more than one home buyers, in many cases to 3 or 4. So now question was how to treat them, whether for a single flat I should treat all of them as the home buyer, then question will be how we will be dealing with them in the insolvency resolution plan. So that question was there. So we constituted separate classes there also. We constituted one class of home buyers. We called them the original home buyers, and then subsequent class was where they were the subsequent buyer of the same flat. So two separate list of creditors were prepared, which was objected to by many. They said no, actually the home buyers, they constitute a single class. Even in both the matters, this question was raised, but finally NCLT, they said no, it is possible because they are different, their interests are different. So I think this is a thing which I have seen in this matter only. I have not seen in many other matters where different classes have been constituted in respect of different projects. So though finally resolution plan is to be approved, but still this issue is being raised before Honorable Adjudicating Authority, that the classification which has been made of the home buyers into different classes project wise, that is not something which should be accepted. So a serious objection is there on account of the same. Okay, so this was something.
Thank you very much, sir.
Yeah, Mr. Sunil.
Yeah, thank you very much, and it was very great insight. Anand sir, do you have something to share with the audience? If some experience that you have dealt with, some nuance.
Sure, Mr. Gupta, thank you very much for having me here. In my opinion, real estate cases are full of challenges. And what I've experienced is either you have challenges of having no information, the promoters in jail, getting no information in terms of ability to verify also the claim. Somewhere the land allotment has been cancelled. In another case, it was a joint development and there is a dispute between the landowners and the developers. Of course, what Mr. Sharma said, a multitude of sales, one flat being sold to many people, that is a recurring problem from project to project. And in addition to that, there is also an issue that whenever a notice is given, it is usually given at the registered office of the corporate debtor. And it is not necessary the majority of the home buyers or the home buyers which constitute hundreds in number may be available only at that place. And 14 days is hardly a time within which you'll be able to get the claim. So what it entails is that if you have a project with say 2,000 flats, within first 14 days, you may end up getting 600, 700 maximum. That's what we have seen across 17 projects or so. 17 cases, we have seen only 30, 40, 50% of the claimants come to you. And then this also causes litigation because people who do not come to know, even after the plans which have been received in cases and COCs approved, the plan is pending before the adjudicating authority for approval, you'll find litigation going on. And the adjudicating authority, maybe rightly so, when a home buyer walks in saying, I have invested 20 lakh rupees, my hard-earned money, I should be given justice. They tend to listen. Of course, in the law, they cannot direct the RP to accept the claim, but this creates litigation. And that also causes most of the cases, there are very few cases where the resolution plan have been able to approve. And one or two cases I know where it has been approved, they have been challenged in NCLAT. So all these issues put together are creating a lot of delay. That's the basic bane of all the real estate CRP proceedings that we are seeing, that it's extremely time consuming. RPs are able to finish the process in 330 days, most of the cases, except like JPs or Amberpali, which becomes a totally different case. But largely the issues that I've listed here cause invariant delay in completing the process or getting the plans approved. There are at least 4 cases in my firm, including my own cases, which are pending before the adjudicating authorities for more than 900 days for approval of the plan. These are the real burning issues.
Thank you very much, sir, for the perspective. Anirban sir, I would like to give the baton to you if you can share some highlights or some experiences which can which can enlighten me as well as the audience.
Thank you, Mr. Gupta, for having me here. Couple of pointers. I'm always a naysayer. People call me as a naysayer, so I'll stick to my reputation of that. Second thing is I'm talking on my personal capacity. So I actually looked up a few things, and I was wondering that you wanted me to comment opening remarks. I'm still wondering 2016 IBC, 2019 Second Amendment, incorporation, and if you look at 2022 March data, out of 223, only 9 cases have actually been in a state of, not closure, but state of completion. Okay. Now, this is a very interesting word, and I picked up from what Anandji spoke about, that the moment it goes for a litigation, the completion, closure, and all those words become so complex, right? And a home buyer, right? Even he may not get a copy of the document within the first 14 days. How he or she will understand the difference between completion and closure. So my point is that we are still evolving big time. We are in the very, very nascent stage of insolvency practice in this country. And when it comes to the real estate industry, I don't want to name anybody, but we already know there are about 50 players, small, medium, even to a certain extent, pseudo large players who have been in various stages of, maturity or immaturity of solvency. Now, the fact is that how do we deal with this from a, end customer standpoint? End customer, poor guy, he or she does not understand, or he or she cannot come to a Nilesh Sharma or a Anand Swanbhadra every time to, get it ratified and validated to go and buy a property with Amrapali, if I had to take that name again. But the fact is, we have to mature fast. And if we talk about the digital India and the semi-phygital India, I don't know, this is my ask as an end user also of the commodity. Can we really fasten this product? Number one. Number two, can we ensure that out of the 223 listed ones, where we really do not see light among almost 160 or out of them, can we drop them or move ahead or make some headway and make some serious attempts to those 50, which are extremely critical and to a certain extent extremely important to make a statement, and which will, I think, free up almost lakh and a half crore for the economy, right? It is almost 100 lakh crore, which is jumped up there. So can we really make it important? Because now the economy is in a soft recession mode. So that is very important. It's a point of inflection for this industry. I would like to state there that it is a point of inflection.
Thank you very much, sir, for your insights. I think it was great. Mr. Dharmendra has joined. Welcome, Mr. Dharmendra. I introduce you as a cost accountant with more than 28 years of experience to the team, the members here in the present. Sir, just a very, very brief, some experience that you have got during this insolvency practice, particularly in respect of the real estate sector.
Thank you, Sunilji. As said by our earlier panelist, I agree and endorse their views. Further to that, I want to add that India is the only major economy where we have a separate provision for real estate cases for insolvency. So this is a unique thing that is only available in India. To the best of my knowledge, it is neither in US, nor in UK, nor in any major European economy. The real estate insolvency is not a separate thing. So for that, our legislatures and regulators deserve some kind of appreciation. So I start with this positive note. However, there is a rider that with the such diverse experience and practices in especially in real estate sector, which is not a very evolved this thing as industry. We call it industry or sector, but most of the players, or I would not put numbers, but most of the players in real estate sector are are not very used to regulated environment, so to say. So first regulation for real estate sector was RERA. To some extent, they were just trying to get acquainted with RERA. In the meantime, IBC came, and IBC separate this thing was provision was included by legislature for home buyers or real estate sector. So these are the two very contemporary and major and important developments for real estate sector to cope up with. And most of the cases that we see today, Mr. Gupta, is for the period which is prior to introduction of these two important legislations. So
exactly.
Pre-RERA period and pre-IBC period. So let's say as a sector, as an industry which was totally unregulated and mushrooming with the unregulated practices, whatnot. I don't want to name on those practices. All of us are aware that what are those practices, and we will deliberate on that, those practices, major practices out of that, whether they are ethical or not ethical. I leave it to the fellow panelists. But the thing is, if you put certain regulation on a totally unregulated sector, unregulated industry, this is bound to happen. So this is a fait accompli that I see that has happened, and all these litigations and delays, whatnot, it is bound to happen. If it had not happened, I would have been rather positively surprised. So I'm not surprised because it has happened. I'm positively surprised because due to such deregulated and unregulated sector has come and confronting with two major important regulations, RERA and IBC, and they are trying to cope up with. So
thank you very much, sir.
Yes.
Thank you very much for your perspective. Milanji, I think I would like to have some words from you as well before putting up certain questions that I have created. So I would request some perspective from you as well, sir.
Thank you for having me here, sir. I'll just have a point out just a quick point which Mr. Sonbhadra had started. I'll just add on to it. It was regarding the claim by a lottee, which is filed post approval of resolution plan by the COC. Now, the idea of barring on putting a bar on admission of claims after approval of resolution plan, that primarily arises because a new claim shall not come as a surprise to the resolution applicant. That is there. I understand as soon as a home buyer or an allottee books a flat and gets an allotment in his favor, his name is registered in the list of stakeholders. Now, this list, of course, the RP goes through it, puts it in the information memorandum, and this list is always available. It never comes as a surprise to the resolution applicant. Therefore, I'll quickly end on this. So therefore, I believe that NCLTs, they ought to take a broader view insofar as the home buyers are concerned, because they cannot be a matter of surprise to the resolution applicant ever. So resolution, the allottees who file their claim even after approval of resolution plan by the COC, those claims also ought to be admitted, and some form of modification to the statute book must come in the coming time. I believe so. Because the idea for not admitting the resolution admitting the claims after approval of resolution plan is to avoid any surprise to the resolution applicant. So that element won't be there in case of a lot. Thank you.
Thank you, Milanji. I'll just come to first question that comes to my mind now to you itself. See, it's a well-defined time-bound program which is given in the code. However, we are finding that particularly in real estate, it is becoming exceedingly challenging for various stakeholders. Stakeholders in this case, I will also include the RPs, the authorized representatives, as well as the allottees. The creditors in any case are there. I'm not saying the creditors are not there. Financial creditors are there, the banks and the FIs and etc. And can you just share some perspective of the challenges that what is the core of this problem? Why these challenges are being faced? Why they cannot be addressed in a structured manner? As I think Mr. Anirban also shared that there were certain problems. Even Anandji was sharing. What is the reason why we cannot address these problems?
So, sir, just to answer your question, your question is, I guess, twofold. First is that what is the heart of the problem? Now, yeah. I believe that primarily the heart of the problem is the debt-ridden corporate debtor itself, who otherwise, prior to coming into CIRP, already has numerous creditors who altogether have different interests. Now, during the CIRP, this leads to a key problem that all these stakeholders, they have a different set of interest and a different set of rights. Now, this problem gains further significance when there are non-cooperating promoters and the management, they do not provide any information. And the authorities such as information, ED, PF, GST, income tax, etc., they are there also to create hurdles for the RP. Now, during the process, all of us know that the financial creditors, they take the driving seat, and the statutory authorities and the operational creditors, they are left out. Now, for a going concern, if suppose a corporate debtor is a going concern and it has certain business operations already going on, the operational creditors, they play a very key role. These operational creditors who are otherwise ousted from the COC, they do not take any interest in the ongoing process of the corporate debtor. So these all set of problems, they all together create a new challenge for the resolution professional as well as the AR. Now, this is the heart of the problem. The solution to this, I believe, is twofold. The first answer would be that obviously IBC has come into effect only in 2016, later part of 2016. So it is barely a 5 odd years old legislation. So it will take its own course to evolve, to develop, and to find answers to such questions. That is there. We all understand that. Now, to enhance the process and to accelerate the process, I believe 2-3 things are to be implemented. The first part would be that the set of duties and rights of each parties and the obligation of each stakeholder must be clearly carved out in the process itself. Suppose GST department is there. Now there is a specific notification by the ministry to the GST department that the corporate debtor should be issued a new GST number as soon as it enters into CIRP. Yet the GST department has been reluctant enough to not provide the GST number to the corporate debtors. I have faced similar problem. I have contested a case for about 7 months, and ultimately the corporate debtor went into CIRP because the GST department did not cooperate. I could not raise the bills and run the business. So all these departments, they must be aligned together. All the stakeholders, they must know their set of rights, their obligations, and their duties. This is first and foremost. Secondly, I understand that the court should also have their roles specified, and they should act very street smartly, and they should take up cases on a regular basis. And as and when the cases of these nature come, the judges, they must be trained in those directions that they deal with those cases strictly. Because at times we have felt that the judiciary, they also do not show that bravery that they could issue directions to particular department in respect of certain obligations which they are otherwise complied. So that I understand is the problem, and those solutions probably will help. Thank you.
Nilesh, coming to you, see, for ARs also, we are finding that for ARs also, the challenges is to address the concerns of allottees. Now, each allottee has its own set of challenges and requirements and grouses. Now, the issue is keep within this time, what do you think? What is the remedial action which can be taken to remedy this situation? Because for an AR to address, for example, 1,000 home buyers, and they are having different challenges, they have made different payments. In certain cases, I am finding that the payment even for transfer of for the OC etc. has been made only, but the OC has not come, and the registry has not been made in the name of the allottee, and they cannot be treated at par with the person who has paid maybe 20% or 15% of the payment amount. Though amount can be captured, but the thing is, these are the things there are different sets of issues. Can you just highlight some remedy that is possible?
Yeah, according to me, ARs are having very limited role under the present scheme of IBC. So you know that under Regulation 16A9, they have to invite the preliminary views of the home buyers or the members of that particular class he is representing, and then based on the same, he has to prepare himself for participation in the COC meeting, and then after that, based on voting by the class, he has to vote as a member of the COC. So he is having very limited role, and you know that his fee is also paid based on the number of meetings he attends. So according to me, there is a need for enlargement of his role. Here we are having a number of home buyers who are not aware of the law. They don't know what will be in their interest. And most of the cases I have seen that very few individuals are there, very few home buyers are there who lead the entire process. Participation by majority of the home buyers is not there. They are not aware of what is happening. Only few home buyers, they are leaders, they are associations, leaders of the association, they run the entire process. And in many cases, their interests are different from the members of that particular association or particular class. So I think AR should play a bigger role. They should be allowed to participate more. They should be, and their fees should also be based on that. I think like RPs are paid on monthly basis. Similarly, ARs also, and they should be having advisory role. They should take the responsibility of guiding the people, guiding the members of their classes. Okay, though ultimately decision making will be with the home buyers only. Okay, but at the same time, I think these people, they should advise the people as to what is happening, what is in their interest, what is not in their interest, so that it should not happen that the leaders of some of the association, they use the process for their personal benefits. So I think larger role for the ARs, that is the need, and expectation of the home buyers is also from them that they will be guiding them, though he is not supposed to do that, but they will be receiving a number of telephone calls, a number of queries. It is expected from them that they will be, that if RP is not doing something, then he has to take initiative, he has to talk to him. But actually under present scheme, this is not his role. I think larger role for the AR should be provided in the act, in the regulations. And then this process, I think whatever issues are there, like very low participation by the home buyers. So I think with the participation of AR, larger participation of AR, I think more and more people, the home buyers, they can be asked to participate, or they can be motivated to participate, so that otherwise they are not having clarity about law. They don't know what is happening. So I think AR should have a bigger role.
Sir, one more suggestion that I can have, one more thought that I was having while you were discussing. In order to have better participation and better representation in the COC, there can be a limit threshold limit for 1 year to represent number of people, so that he can effectively communicate with them as well as to address their concern in the COC meetings. So if, for example, if there are 500 people home buyers, then we can have 2 or 3 ARs rather than 1 AR. That is one thought that has come to my mind for better representation. Thank you very much, sir. Anandji, I think you raised a very pertinent point about the delay in collection of the claims. Now, first, before even claiming having a claim, the issue that we are having, for example, if home buyers want to initiate the process, then what happens that they have to, there is a threshold limit where either minimum 10% or 100 home buyers have to get a combined application has to be made. Now, problem that we are, as a home buyer, you will appreciate, people don't have the contact details of the other home buyers. There is no process in RERA also that the details of the home buyer should be available at this website of the company, the developer, and so that if required, the people can connect with each other and like people can do. So what are the, how can you think, how can this concern can be addressed for initiation of CIRP, particularly by the home buyers or the allottees?
A couple of things. Home buyer is a very disparate lot. You rightly said they do not know each other, and neither is the requirement in the process when they do their home buying. Now, how do we get? I think there is one correction that I would make. RERA requires the builder to keep quarterly update on the bookings he's made and the details of the bookings. So one can look at the RERA registration number, against that the information that a builder has to put, the booking detail has to be there. I don't claim that every builder is compliant, but most of them, as we go along, have to do it, except for the stalled project or abandoned project. That's one. Of course, the other choice for them is left with to interact with fellows and amplify the communication. There is no other choice. If they want to go for CIRP, they will have to get 100. Law will change when it will change based on a lot of feedbacks and things like that, and liaison done by various parties with the government. But till such time the law changes, mechanism will have to be devised by home buyers, either reaching out to each other, reaching out to association. In my experience, I have seen most of the cases, the association have some or the other information. And that can be, you can do RTI with landowning agencies, because most of the landowning agencies have dual role, and where they have a separate role of land provider and the town and town planning department separate, one can do an RTI with town planning department, which also takes the list of how many flats have been sold, which are the bookings made, because different legislation have made it incumbent on the promoters, be it RERA, even NCDRC. If people were to go, they're obliged to provide information. But RERA in particular requires that each and every builder provide the information of what is the booking that has been made. Landowning agencies like Noida Authority or Greater Noida Authority or Town Planning of Gurgaon, I'm just speaking on behalf of, per se NCR, or even PUDA in Punjab, or SIDCO or MADA in Mumbai and MMR region, they insist, of course, the mechanisms that these agencies follow are very, very different, but they insist on the list of registries done or list of bookings that are made is available with them also. So an RTI done with this agencies can also reveal. In many cases, we have got the list because promoters have run away. As RP, we have been able to get, for verification purposes, made somebody do an RTI, get the list from landowning authority, what is the information that the builder shared with the landowning authority in terms of what is the sale is made. So these things would help. And of course, I know home buyers do not make an investment for business. This is an additional burden on them to make that extra effort to be able to take the, entity whoever is defaulted against them for a CIRP proceedings.
Thank you very much, and definitely it's an additional burden, as well as see it's a chaos for in their life, because they put a hard-earned money into the business, into the projects, and they are just getting into a lurch where they don't know exactly what to do with that money, and now what will happen to their money, whatever they have deposited. Thank you, sir. Thank you for your point. Now, Dharmen sir, I'll just put this point to you. It is necessary to provide RPs the tools, powers to seek requisite information from the non-cooperative suspended directors, promoters, and entities. But in my experience, and I feel as we discussed in the initial thought, there is a big challenge. Promoters in some cases are behind bars. Sometimes they are incognito, they are not reachable, they have run away, and the information is not available. And that practically creates a very, very big challenge for the RP to complete this process. Now, how can this non-cooperation can be handled at the best law? Because see, if I file a 19(2) application and I wait for the decision of the court, it takes a lot of time and a lot of water flows with that time. So what is your suggestion, or what is your advice? How to speed up this process? How we can handle these situations, sir?
Yeah, very pertinent question, Mr. Sunil. As we were discussing, real estate cases are little bit different and more complex than the other corporate debtor cases. So it is not a apple to apple comparison. As you said, 19(2) applications, there is nobody at the helm. Most of the time, these promoters are facing several other litigations, criminal as well as civil, enforcement directorate, and all those things. And they are trying to save their face and the property and the company, and it's endless litigation, and CIRP comes in between. So it is CIRP, when CIRP comes, or this admission order comes, already a lot of litigations are there going on, whether in NCDRC, RERA, or all other forums, enforcement directorate, economic offense wing, so on and so forth. So in such a situation, 19(2), even if adjudicating authority gives a clear-cut order, there is nobody available there to comply with the directions of the adjudicating authority or honorable NCLT to comply with the 19(2). In most of the cases that we have seen, that CRM, customer relationship management system, that is also not updated to a great extent. So what RP and IRP and AR does, they try to get the updation of that CRM system, try to update the customer database, try to match the claims with the CRM information, and so on and so forth. So when we start getting, RP starts getting claims, they try to corroborate with the books of accounts or CRM system of the corporate data, and then one by one these things comes on the surface that these are the differences, and there is nobody readily available in most of the cases to answer all the queries, that why this difference, why the books are not matching, CRM is not matching with the claim and all that, so on and so forth. So it's a complex situation. And in this complex situation, I don't find a ready-made solution or this thing. So depending on the situation and each and every case, RP or IRP takes help of different professionals trying to get it updated, takes time, and it's a very challenging thing to get into the pace. So as second part of your question is timely process. So this timely process, timely completion process, the 75 days you have to come out with as RP or IRP, you have to come out with the fraudulent and other transactions, your views on that, then information memorandum preparation, and so on and so forth. So each and everything is time bound. But the basic premise that information, whether it is half cooked or full cooked or available or not available, how to what extent it is reliable or not reliable. So in figuring out these things, in most of the cases, we have seen that this time of 75 days goes away like this, and time flies, and at the end of 75 days, RPA starts thinking that, I have missed this timeline, that timeline, and and then all those challenges and trying to get answer to, and then people try to blame RP that he is doing this deliberately, and so there is no fix, there is no panacea for all these diseases. But yes, this is a very challenging state of affair, and real estate cases are each and every case is different and challenging in itself. And as we discussed earlier, it is mostly coming from pre-regulatory period, pre-RERA, pre-CIRP, and things like that. So all those mushrooming real estate companies have come up, and most of them have left, right, center growth plans and everything, and they have funded, unfunded, secured, unsecured, by all means. So even if with some due diligence or this thing, I'm constrained to make this point that even in the cases where resolution plan have been submitted, RP and AR and other stakeholders are not confident about the completeness of the information provided through IM, because it is as is where is basis, and they say that whatever was available to me, to the best of my knowledge and belief, I have compiled, and this is it. So nobody can. So information dissymmetry is a big issue, and that takes or that explains, information dissymmetry explains the delay in resolution, because except that promoter himself or herself, all other resolution applicants are not at par with the availability and analysis of the information about the corporate data. So any third party, any resolution applicant who comes, he or she is supposed to compete with the promoter per se for his or her resolution plan, and the information available is with him with a lot of effort. The poor RP has put together something in the name of information memorandum, and that's it. So information dissymmetry is the primary reason for taking time and getting not very comparable resolution plans, and so on and so forth. So these are the some of the issues or major issues that I have come across, and in terms of non-cooperation, non-timely completion of this thing. So these are the things, but everything cannot be present in one case, or in every case we cannot apply same yardstick. So it's different in different cases. But yes, it's a very valid question, and the job of RP is very challenging. So my whole appreciation for poor RP that struggles to get a time-bound process, which was not there, which was untime-bound for last 10 years or 15 years or so. But immediately after admission, everybody starts expecting that everything will become time-bound. So this is unfair expectation on part of the stakeholders from RP, and that the moment the case is admitted, everything becomes time-bound. So this is a paradox.
Thank you very much, sir. It's a great thought that you have given. Anirbanji, I think a very pertinent question, particularly for a home buyer. See, the primary objective of a home buyer, as well as the financial creditors, particularly the lenders. Though home buyers are also financial creditors, but they're having different competing claims. Reason being, both have funded the project, and home buyers are not privy to a lot of information which a lender was privy to and is being privy to. See, now the challenge is that both of them have funded the project, and how the home buyer will be classified. The home buyer does not know whether he will be considered as a secured financial creditor or an unsecured financial creditor, and if it is considered as an unsecured financial creditor, then on the packing area list, he goes below the secured financial creditors. Now, definitely there is a challenge for him, because though legally he has been brought to participate in the COC, but still there is some doubt of its classification, though I will say initially the chairman IBA clarified that based on the BBA you can classify them. But still, I feel personally that there is a challenge to it. How do you think to address this time? Because this is something which is a gray area. What are your views on that?
Fantastic question, I must appreciate. And I also want to appreciate you for setting the context so well. See, the fact is, this is always an open race. And as Dharmendraji was speaking, right, it is a paradox which is yet to be unbundled, and the same concept lies here also. But my humble submission to all the visitors and all the followers who are taking notes today and who are also maybe going to watch this over YouTube, and if you are a home buyer, see the point at which we go to a lender as a home buyer. I'm talking purely as a home buyer perspective right now. We have to understand what is the quality of asset that lender is going to create, right? And the moment they have to read through the minds of those mortgage assessors, and see, we are still, and I must again give a commendation to Dharmendraji. He said that ease of doing business, we did a great job. We came up with our first IBC in India and with a proper positioning. But I was just looking at some of my notes from US GLBA and US Mortgage Act of 2017. If you look at the way they really created the path for the home buyers in terms of information, I expect government to also play a very constructive role in that area, and hopefully the data protection bill has been stopped. The non-personal data is still an open subject. Milan is already giving me that look. I hope they are able to push through their cases and get that non-personal data qualified, because that qualification is very important. So from a home buyer's perspective, whenever that person is going and getting in that assessor's actions ratified, that is the point. They also need to really be an equal player. What happens is, and this is even my example I'll give, home buyers understand the expectation of the in the agency. They take the expectation of the agency and put that expectation. They just act as a courier company. I don't think none of the home buyers are working for DTDC or DHL, right? They pick up an email from their whoever is the lender, be it a Schedule A, Schedule B, or an NBFC. They take up that and give it to them. They pass on some information. They act as a conduit. Can the home buyer mindset change? Because we are in 2022. We are talking about a phygital economy. We are talking about economy where, ease of doing business, we are 87. Can we really make our home buyer awareness, okay, the awareness levels? Because guys like Milan and you can really play a very constructive, role in creating that awareness. There's a lot of awareness campaigns which have come in, right? There are a lot of banks, I don't want to name them, they have brought in huge amount of data in their applications, in their portals, which is available to stakeholders. But what happens is the home buyers are more happy to measure, okay, my balcony is whether 10 feet or 8 feet. Okay, can you just go back and read whether this has an ROC, or there is a reverse ROC which is applicable? Have you checked whether there's a clean documentation? I liked the Anandji's idea that an RTI can solve the problem. But what happens is home buyers' mind when looking at the buying proposal, they don't consider any of this. Okay, they want to see, okay, project A, project B, project C. Distance to station, distance to bus. I'm just considering a Mumbai scenario. They always calculate from that perspective. Oh, this is the highest value for money in return terms. Can you also add one more qualifier to it, that what is the most critical documentation provided to you by the your agency or your builder, your provider? Because a lot of times what we see is there are definitely A-grade builders. I'm not going into them. There are pseudo A-grade builders, okay, or pseudo positioned A-grade builders who advertise a lot. Okay, home buyers get lured a lot by those advertisements. But home buyers have that responsibility of using that intelligence, because I'm sure most of the home buyers today have access to information. And if they have access to information, they really need to make use of it. That is where I go back to your question, that classification will remain as an opaque one. People want to keep it opaque. Nobody wants to bring in transparency, because the moment it is transparent, everybody will know that they don't have chair in the table. Okay, it's a tableless chair. So that's where the problem is. And I would strongly recommend every home buyer to really help them with 1 or 2 more days, maybe a one weekend. This is the typical metro city phenomena, right? All the home buyers in India, weekend will go and search a home. Weekend don't go search the home. Weekend, please do your documentation. Okay, dedicate 1 weekend for documentation and then go for your home buying. I think that's my message to all my fellow home buyers in the country today.
I think that was a great advice, and that's why, see, the objective of this webinar is one more objective, was the awareness. And I think I will appreciate your point, and I will say it was a great thing. Now, actually, I'm running out of time. I'll take some 2 or 3 questions that I have received on my screen. One of the question is Ms. Rachita Chawla, which says, sir, if a project being developed by 100% subsidiary of a parent company, is it mandatory for the CIRP against the subsidiary be also initiated? Anandji, can you throw light on this?
No, I think we have to understand the CIRP can be proceeded against a company, which is the default. What is the critical item or critical ingredient for initiating CIRP? There has to be a debt and there has to be a default. And you cannot hold responsible a holding company for the default of the subsidiary company. I'm not talking about at this moment group insolvency. That's a separate topic and that's a separate mechanism. But on a standalone basis, if the default has been done by the subsidiary company, you cannot, in my opinion and experience, your application for CIRP of holding company will not stand, it will be dismissed. That's my simple reply to the point.
Milanji, another question that I am having on my screen is any criteria for an RP that he should follow before proceeding with registration of home buyers? I think I could not get this exact question from Mr. Vinod. There are two things: how the RP is legally covered if they allow registration from unregistered home buyers. I'm sorry, I could not get this question. Let me take some other questions if they are available. Vinod, is there something?
Allow me to speak, Sunilji. Can you hear me?
Yeah.
I just take half a minute to elaborate on the point which Mr. Negi had made, that
yes, sir,
the home buyer should be, their claim should be allowed. One of the mechanism, law being what it is today, but one of the mechanism that I advise to all my resolution applicant, two things. One is the maximization for every stakeholder will happen only when the project gets completed. The second thing, when the plan is being built, to avoid litigation, save time, save cost, resolution plan should contain one particular clause which allows any unclaimed or undecided claim. Anybody who is not claimed, any home buyer who has not put up his claim or her claim or any undecided claim till the time it went for voting in COC. Those can be claimed after the approval of the resolution plan by the adjudicating authority. A clause inserted in the resolution plan gives that power to the RA and the monitoring committee to view the unclaimed inventory or unclaimed claims to be verified and registered for the genuine home buyer. We have done that in many cases and it works. So that people who are left out, they do not suffer unnecessarily. In fact, there is quite a bit of debate going into NCLAT, etc., on similar cases which are coming there. I thought it was important to add.
Thank you very much, gentlemen. I think it was a great session, and it was a great learning for me as a person. I think my audience would be enlightened by your wisdom, and I thank you for your time. I don't have much time to continue. There are a lot of questions that I am having from people, but let us take maybe another time, or we'll respond it through the mails. Thank you very much, gentlemen. Thank you for your time.
Thank you.
Thank you so much. Bye-bye.